All right, folks, let's bring in our guest. I'd like to welcome criminal defense attorney Sam Bassett is with us. Sam, great to see you. Always a pleasure to have you on the program. And let's talk a little bit about what this question, the latest question, we'll get to some of the other questions, this latest question, asking for a readback of Cassie's testimony, some of it involving her relationship with some of these folks who were involved in the freak-off, some of the sex workers, escorts, I'll call them. What do you think might be going on? What is this jury looking at this point when you consider the context of the charges that Diddy's facing?
Well, I think the issue must be whether or not Ms. Ventura was directing some of these people, or if she was working at the behest of Mr. Combs. That's the issue. But the process that's probably going on is there's probably a little bit of a divided opinion about the issue of, was Ms. Ventura acting on her own, or was she acting under coercion or pressure from Mr. Combs?
You know, one of the interesting things in the prosecution's closing argument, they made clear that while some may have been consensual, she may have wanted to do some, may have enjoyed some, that doesn't mean that all of them were consensual. They pointed out a couple of ones where clearly she might have been coerced because of some videos that he had of previous freak-offs. There's one time where she had a UTI and was getting involved in it, and they were saying, look, she had said she didn't want to do it, she was forced to do it, he used coercion to make her do it. So I think that's an issue here as well, because you really only have to find one instance. You don't have to find this ongoing pattern as far as the coercion goes.
Yes, and it's kind of like the evolution of sexual assault prosecutions in the country over the last 20 or 30 years. We don't always absolve somebody if somebody starts out consenting to sex and then at some point it becomes non-consensual. This is obviously a much larger version of that kind of analog, but what we have here is a very long relationship between Combs and Ventura. And are there points intermittently or even regularly where she is doing this because she has to, versus because she wants to do it? And that's really the issue that covers so much of this deliberation, I think.
Yeah, I agree. I think it's going to be very, very tough. Now, at the very top of the verdict form that they're looking at, there's the racketeering charge. First thing I want to do now is take a listen back to AI. This is an AI rendering of the prosecution's closing when they try to define racketeering for this jury. Let's take a listen.
So let's start by talking about count one, the racketeering conspiracy. You may have heard the term racketeering before in the context of mafia or organized crime, but the concept is simple. The law recognizes that when someone commits a crime as a part of a group, what the law calls an enterprise, they're more powerful and more dangerous. That's what happened here.
Look, Sam, they really needed to simplify this whole racketeering thing, because I think that word has implications for all of us, for jurors as well. They simplified it, and I think when you look at it at its base form, it's not too difficult to say that he involved his enterprise, he had this enterprise, and he committed these criminal acts. Therefore, it's racketeering.
That's correct. I think that the jurors come into a trial without any knowledge of the law, and the prosecution did a good job there of trying to simplify, put on a bumper sticker, so to speak, what racketeering under the law really is versus what they may have heard in the movies or in crime novels or in documentaries.
Exactly, and that's the problem. Now, here's my question for you. If there's going to be this disconnect between this idea that this enterprise, its main purpose wasn't for some sort of criminal activity over this wide-ranging, criminal enterprise. It really was for this freaky lifestyle that he had. So is there a chance that jurors may look at this and say, you know what, yes, he committed these crimes. Yes, it seems to be that there's racketeering, but it also has to be the criminal acts are in furtherance of the racketeering. And when you look at it, it was really about music. It was about a whole bunch of other things, not necessarily all about his sexual pleasure, his sort of swingers lifestyle, as the defense called it. And there may be this disconnect and difficult for the jury to take that leap. Do you think that might be an issue for them?
Yes, it's a complicated charge. It's a complicated jury instruction. The jurors must have spent the first half a day of deliberations just trying to understand the law with regards to the instructions. And then the racketeering part of the case is definitely the highest hurdle for the government to jump, in my opinion. And you're right, they have to conclude that the enterprise itself was not about music and money. It was about coercing people to do acts that they didn't want to do, and coercing sexual acts, basically.
Yeah, and a bunch of other things. So, for instance, there was the arson, and again, that's Kid Cudi's car. They could find that, and again, they only have to find two, and they don't have to be unanimous on the two. One juror could find two, and a very different two for this other juror. So that makes it even easier for the jury as far as that goes. And they had a question yesterday, Sam, that involved the distribution. And as you talk about sort of following what the instructions were, this is what they asked the judge, referring to page 37 of the jury charge. If a recipient wants, requests, or asks for controlled substances, and an individual hands over controlled substances to the requester, has the individual who hands over the controlled substances distributed? So there's a question that I think would fall under the racketeering when they're trying to sort of fill in the blanks as to these two acts that he would have committed to constitute the racketeering, considering the way it was answered. The judge basically said, look, you're going to follow the rules, and here's the way he answered: actual, constructive, or attempted transfer. This is the definition, and this was in sort of the jury instructions: to deliver, pass over, hand over something to another person, or case it to be delivered, or cause it to be delivered, passed on, or handed over to another. Distribution does not require a sale. Again, it's pretty straightforward, Sam, that perhaps, based on some of the testimony we heard, that there was distribution per the definition. But again, it feels like it requires a leap for this jury that this was involved in some sort of criminal enterprise. What do you make of that question by the jury?
Well, I think the answer to the question and the definition pointed out to the jury definitely benefits the prosecution, because the distribution can be to a willing recipient who doesn't even pay for it. So I think that helps the prosecution if they focus on that definition, and thus it also helps the racketeering. Obviously, some of the jurors are struggling with the issue of consensual behavior versus coerced behavior in this whole enterprise, in the whole course of conduct of drug using, the physical abuse aspects, the sexual aspects. It's really a unique case in the sense that the defense can credibly argue that the people participating were not forced to do anything.
And that's going to be my final question for you on this issue. One of the things that you need to prove if you're prosecutors is that there was this meeting of the minds, this agreement. If these people worked for him and they basically were doing what he said, how do you get to this agreement for the furtherance of this criminal activity? When they're basically doing their job, they're not even 100% sure what they're doing, why they're doing it. He's just telling them to do it. Is that an issue?
Well, it is in a psychological sense, but you can be a member of a conspiracy and also work for somebody. So maybe it started out as legitimate employment. Your job title was X. Oh, but by the way, I'm going to have you do this other stuff too. And you're going to participate in this activity knowing that it's illegal. So you can have both a legitimate job and also participation in a criminal conspiracy.
All right, fair enough. All right, Sam Bassett, stand by. I do need to take a break here. Folks, coming up, we're going to head back to Connecticut for the murder trial against Raul Valle. Stay tuned. We'll have much, much more coming ahead. Keep it here on Court TV. All right, so that was it for the defense's case. Raul Valle up there trying to save himself. Let me bring back in my guest, still with us, criminal defense attorney Sam Bassett. Sam, I'm going to ask you, on one level, it felt like a bit of a Hail Mary. There were some facts that might have been helpful to his story on cross-examination. I thought a lot of that was undermined by what I thought was a very strong cross. I thought there could have been more objections by the defense, but what do you make of his time on the stand?
I think he overall portrayed a fairly innocent, mild-mannered personality, probably did a lot of work before he testified. But I agree with you, the cross-examination, especially the end of the cross-examination, is pretty devastating to the defense, in my opinion. He went back to the property with a knife, As you know, and you may have mentioned in earlier broadcasts, Connecticut has a duty to retreat statute as part of their self-defense, unlike some other states. And the fact that he went back on the property after he had some issues before is a real difficult fact for the defense to overcome, in my opinion.
Yeah, you have the duty to retreat. You also have the aggressor issue where if you are the aggressor, you do not get the right to claim self-defense at that point. Without the invitation, which clearly he did not have, he returns to the property. And the testimony is that he was hit first once he returned to the property. What does that do to this part about him being the aggressor? Again, returning without an invitation. He claims he was going back to make peace. That's a little bit difficult to believe. But he's on their property, doesn't have an invitation. He is hit first. Does that affect who is the aggressor?
Well, overall, you have to look at him being there. If he's approaching someone and someone strikes him, it's a debate who the aggressor might be. Just because he didn't throw the first punch doesn't mean he wasn't being aggressive in approaching someone and getting hit.
Yeah, I would agree. Let me quickly ask you, this may become a case where we're more concerned about manslaughter versus murder than murder, right? If you're the defense attorney here, after that cross-examination, and I think one of the most important issues is perhaps when he gets the knife. He claims he got the knife prior to going back to the property. Others claim he was at the property, things were going down, then he went to the car to get the knife. I think those two things make a big difference how this jury views this case in terms of murder and intent versus manslaughter, where he may have been just acting, let's say, with gross negligence or negligently, or recklessly under the circumstances. What do you make of that, and that's sort of the difference between when he gets the knife and how important that is to the case?
Well, obviously, I think if he goes and gets the knife in the middle of this event that took several minutes, and then he's leaving the event to go get a knife to come back to the event, that's a real problem for the defense, I think, because it shows I'm going to go take care of these people versus just having the knife all along. Obviously, it's not a great fact either for the defense, but in the moment, he pulls out the knife that he's had all along to defend himself is a little more sellable, I think.
Yeah, I would agree. I think it's important how they view that aspect of the case in terms of how they judge him under the circumstances. All right, Sam, stand by. We're going to take a break here. Folks, coming up, we're going to take you back to court for some arguments by the defense. So please stay with us. Still with us, criminal defense attorney Sam Bassett. Sam, they were deliberating about 13 hours or so. We stopped that verdict clock. Here we are after 3 questions by the jury over the course of 2 days. Today involved some readbacks involving Cassie, the incident of domestic violence at the Intercontinental Hotel. Also, some of the readback involved one of the escorts who had situations with her, a couple of situations with her. So your thoughts now that the verdict is in after 13 hours of deliberations?
I think if I was the defense, I'd be concerned. You know, I still think the racketeering count is probably the most difficult count to find him guilty on, and it will be interesting to see what if their verdict is split or not. I'd be shocked if it's a full acquittal, but I was not. Obviously, I didn't observe the whole trial, so I'm never critical of a jury's decision, but based on the anecdotal facts as I have them, I'd be concerned if I was the defense right now.
Yeah, I would have to agree. And my understanding as we continue to get information from Manhattan, the jury has actually reached a verdict on 4 of 5 of the counts, which I guess means maybe they were hung on one of the counts, Sam.
Maybe, yes. It's hard to say. Obviously, there was some division going on, or it wouldn't have taken 13 hours. But on a case like this, 13 hours is not a real long time.
Yeah, I'm a little surprised, actually, that based on the question they got this morning, now we found out that what they wanted initially, or at least what they had asked for, could have involved about 800 pages of transcripts. Now, the judge definitely pared that down, and obviously they got that around 12 in the afternoon, probably went at it after lunch, so they've been looking at it about 3 hours or so. Does that surprise you that they went through that? It sounds to me like they were looking for something specific. Maybe there's 1 juror, 2 jurors who were feeling one way, and someone thought thought that by reading back some of the information in those transcripts, they could convince them one way or another. That's kind of what it sounds like to me.
Yeah, I think jury dynamics are always mysterious to me, even after having done this a long time. But at the same time, most of the time you're dealing with one or two jurors who are like, I don't really think she said that, or I'm not really sure that that's what she testified to. And then the foreperson or the jury might decide, look, let's get the transcript, and then we can look at it to make sure the majority of us that feel X way are correct. And, you know, that's just speculation, obviously, because every jury I've had, juries never fail to surprise me in how they reach decisions. I've become a little better at predicting overall results, but how they do it is different almost every time.
Yeah, it's a special alchemy that only those 12 people can really sort of work through. And that's one of the beauties of our system. Now, again, the situation is fluid. We continue to get information from out there in Manhattan. My understanding is that currently, Sam, the defense wants this jury to continue deliberating on that count. Remember, I said that they had a verdict on 4 of the 5, and they want the jury to continue deliberating to try to come to a conclusion on that 5th count. What do you think the judge might do?
He might let them deliberate more until they come back with a note that says we're hopelessly deadlocked on the 5th count. If I was a judge, I'd consider that certainly for another day.
Yeah, it sounds to me like that's the right argument to be making if you're the defense in this case. And I would imagine the prosecution might want the same thing at this point. I mean, being hung on a particular count doesn't mean that the deliberations is over on that particular count. There may be more that they can work through. And we've seen so many times when given an Allen charge where the jury is told to go back and continue to try to come to some conclusion, they often do. Sam?
To come back the next morning and have a fresh start at it.
Yeah. All right. So again, we are waiting to find out what the verdict is in the Sean Diddy Combs sex trafficking case. We found out moments ago that the jury handed a note to the judge. We thought it might be that they wanted to go home, but in fact, it wasn't. Although they will be going home soon, we'll have to wait and see. But they do, in fact, have a verdict in the case. Our understanding is that the verdict is 4 out of 5 of the counts, which means they may be hung on one of the counts. The defense is currently or recently has asked the court to continue to deliberate on that 5th count. And I had asked you about that, Sam, and we had some technical difficulties. I want to go back to that question. It seems like that the defense is asking that the deliberations will continue. So do you think that's the right thing for this judge to do?
I think the judge has to consider it. I mean, we're in a holiday week. There's one or two more days they can deliberate. I don't know that I would go too far beyond tomorrow, but I think the judge has got to consider letting them continue unless there's some indication they're hopelessly deadlocked.